Good evening all, my name is John Dove and welcome to tonight's session. This is the final session in our second series of Q&A sessions, and tonight we'll be focusing on personal injury and clinical negligence. And I thought that this would be a good session for people to attend and watch, because a lot of people tend to start or find careers within PI and clinic, particularly as paralegal roles straight out of university, and then going in and building a career from there. So I thought that this would be a good session for law students to watch. We've got quite a healthy panel tonight. We've got 5 people on the panel, so I'm sure that you'll pick up a lot of good tips in relation to these areas of law. I will say that this session is being recorded for YouTube, so if you'd like to keep your camera off, you're more than welcome to do so. So I think we'll start tonight by introducing all of our panelists. So first panelist that we have is Andrew Pope. If you'd like to introduce yourself.
Yes, so as John said, my name is Andrew Pope. I'm a pupil barrister at Liverpool Civil Law. I started my pupillage the week before lockdown. So any advice that I can give is very much to do with post-lockdown and COVID. It's certainly been an interesting last few months, shall we say. But now in second six and doing hearings on a daily basis.
Thank you. We have Jamie Hill.
Hello, good evening. My name is Jamie Hill. I'm a barrister at 9 St John Street Chambers in Manchester. I was called to the bar in 2016 and I've been a member of Chambers since 2018, and I only do personal injury work.
Thank you. We have Marc Asquith.
Good evening, folks. I'm clearly going to be the old fart here. I have been both a solicitor and a self-employed barrister, and I am now an employed barrister with a niche firm specializing in aviation matters, and some of our practice is aviation personal injury work. I was called to the bar in 1999, and I'm a member of Kenworthy's Chambers in Manchester, as well as being employed.
Thank you, Marc. We have Richard Biggs.
Hi, good evening. I'm Richard Biggs, Senior Associate Solicitor at Irwin Mitchell, based in our Manchester office. I specialise in claimant personal injury, got over 20 years experience doing claimant PI. My practice is all catastrophic injury cases, predominantly brain injury, spinal cord injury and amputation work, so quite a wide mix.
Thank you, Richard. We have Niamh McGinty.
Hi everyone, my name's Niamh. I'm currently doing the bar course. I work part-time as a serious injury paralegal in Richard Biggs' team. I was successful in obtaining pupillage during lockdown. I'm due to start in September 21, so hopefully I can be of assistance in helping any prospective barristers through the process if you've got any questions.
Thank you. So we have a good range of experience on our panel tonight. The way that the session is going to work is we will start by going through the pre-prepared questions that you will have sent through when you signed up for the session tonight. So we'll spend around 40-45 minutes going through those. And then in the second half of the evening, we will work through any questions that you have on the night. So if you think of any spontaneous questions, pop them in the chat box in the bottom right-hand corner, and we'll come to those. Or if you're feeling brave, in the second part of the evening, you can pop your hand up, come on screen and ask a question. So it's entirely a matter for you. So what we'll do is we'll jump right in with the first question, and it's quite a broad one. It is, can you describe a general working week in the life of a personal injury or clinical negligence barrister or solicitor? Marc, would you like to get us started on this one?
I think as the evening progresses, people realize I have 5-year-old twins who will come in and out from time to time and are not reliable on being quiet. The question, I think, has to divide into two, which is COVID and not COVID. COVID, I find we are doing, I'm working really as a solicitor nowadays. And the reality is that we are preparing cases continually now as the courts come back to life. There was a complete period of shutdown for us between March and June Indeed, my main court is Uxbridge County Court, and that was physically closed. So there was a long period where we were sending stuff off and it wasn't getting to the court. But we're back up and running. And I think the reality is for me that the courts are coming back to life and are actually overwhelming us. There's an awful lot of telephone hearings going on. And indeed, I had a case today adjourned because the telephone hearing provider couldn't actually cope with the booking. They're too busy. So it's suddenly got hectic again following the shutdown. I think I'll leave somebody else to answer a bit more.
Thank you. Richard, would you like to talk us through a general week from a solicitor's point of view?
Yeah, thanks, John. As Marc says, I suppose it can be divided into pre-COVID and post-March lockdown, really. Before lockdown, no 2 days are ever the same for us in serious injury, because we have to adapt and evolve according to the changing circumstances of our clients and our cases. And so you never know what you're going to expect as you walk into the office during the day in the morning. But typically we tend to go and see clients once or twice a week at least. So we're always out on the road seeing clients. The work we do means that it's absolutely imperative that we see our clients in their home environments to understand what their struggles are, to meet their family and to understand how they cope on a day-to-day basis. So we'll see clients typically once or twice a week. We may be in court. I don't do as much advocacy, so generally we're shadowing counsel. Might be in court once every couple of weeks or so, and then 2 or 3 days in the office with colleagues, which is what we're missing at the moment, because since March we're all home-based. We're going to be home-based until early next year, I think, at the earliest. Bit of a different situation and bit of a different experience for us all. So we're working remotely. All our court hearings are remotely. I've not seen a client for 6 months, sadly, missing my clients massively. So it's a very different experience. I can't wait to get back to where we were.
Thanks, Richard. And lastly, Jamie, from a self-employed barrister's perspective, how would you describe a general working week?
Well, each week is obviously different. For me, being very junior prior to lockdown, I was in court most days, physically in court, either doing, fast track trial application, disposal, whatever it may be. Now I spend most of the time sitting at this very desk, either on a CVP, which is a court's own video platform, or Microsoft Teams, or on the telephone, doing court hearings. And just picking up on what was said earlier, I think after COVID and the lockdown hit, probably a lot more collaboration with solicitors, thinking about preparing for trial together. When are we going to have a conference? What kind of setups required for the claimant or the witnesses, so on and so forth. So there's been a change there. But in terms of a general working week, it just depends. It varies because, of course, as you say, self-employed, it depends what your instructions are. It depends what's in your diary that week. You have busy weeks and quieter weeks, but generally it is in court or doing court work most days.
Thanks, Jamie. Okay, we'll jump on to the next question now. The next question is, why did you choose to practice in either personal injury or clinical negligence? Andrew, you've obviously recently started pupillage. Why did you pick this particular area?
Well, being completely honest, it was not something originally when obviously you did a bar course and people say, what do you want to do? And you think, oh, crime or something like that. And I was working then as a county court advocate, solicitor's agent for 3 years, and the type of work that we did, the type of small claims, and basically it was all personal injury based mostly. And the more I did of it, the more I found actually I really like this, and I really like the side of it where you're seeing these good results and you're seeing a sort of a positive outcome. Or that was to the extent that I was seeing it, because it was all pretty much claimant only work. So when you then look at it, I was like, well, okay, I actually enjoy this. I actually think I'm not too bad at this, and I've been doing it for a few years. I'd actually like to continue in this. So even though I didn't start out originally wanting to go down that path, I've now come down this path and I absolutely love it.
Thank you. And Niamh, how about yourself? Why did you pick this particular area?
Well, prior to working as a serious injury paralegal at Irwin Mitchell, I was actually working as a court clerk at Mitchell Street Crown Court. So I had a huge amount of experience in criminal law, and I was doing my graduate diploma in law, and I had about 18 months before I started my bar course. And I wanted to be able to go into pupillage applications and deciding what I wanted to do with a bit of a wider range of experience. So as much as I enjoyed criminal law and I loved that, I wanted to be able to get a different experience in another area of law. And to be honest, personal injury, I kind of happened upon it. But then when I started working as a serious injury paralegal, much like what Andrew said about it's claimant work over Mitchell, so it's seeing the success largely of the cases and being able to see how your work impacts on a client's everyday life that has suffered catastrophic injuries in a lot of the cases that we deal with, and the positive impact that your work can have as a direct result.
Thanks, Niamh. Marc, I think you'd like to comment on this as well.
Thanks, John. I think it's important to realise that it's very hard to choose the area of law that you end up with. If you'd asked me 30 years ago which area of law I wanted to practice in, I would have said aviation. But I started practice as a general civil practitioner, and it was only that I made a few contacts accidentally through my personal life and the like that in the end I started practicing in my desired area. The reality is, I think that you have very little control. The sole big bit of control is that when you start applying for training contracts or pupilages, if you apply for a criminal pupilage and apply to a criminal set, you might get to do criminal work. And if you apply to a civil set, you'll do civil work. But steering it in any level of precision is incredibly difficult. And I frankly put down my experiences to where I am now down to fundamentally a lot of luck. That's it.
Thanks, Marc. I think I'd like to input on this as well. Even as a criminal lawyer, I did have a past in personal injury and did practice in this area for a few years. And I think that what I like particularly about personal injury is it makes you a very well-rounded lawyer. It covers all the bases of what's expected as a lawyer. So as a general rule, if you're a claimant PI lawyer, you have people as your clients. It's not corporations, it's not industries, it's actual people. So you have a client-facing role from that perspective. Quite often these cases involve liability disputes as well. And whenever it involves liability disputes, it's a very fact-sensitive area of law. And that makes it quite interesting from that point of view. But not only is this a fact-sensitive area of law, there's also a lot of black letter involved as well, black letter law. So for example, whenever I was dealing with employers' liability cases, you'd often be looking at statutes or regulations. So you'd have to be dealing with those particular pieces of law. And also there's a lot of applications that are involved to the court. So you're constantly referring to civil procedure rules. So it really covers all the bases that's involved for being a lawyer. So I think it does make you a very well-rounded lawyer in the whole. And that's why I particularly like personal injury. Okay.
Can I jump in, John, as well? May I just jump in as well?
Yeah, absolutely.
Give you my experience. So the end result of a personal injury case is always an award of compensation for an injured claimant. But I can genuinely say, hand on heart, that that's not what drives me and not what gets me out of the bed in the morning to go and do my very best for my clients, because as Niamh said, we see our clients' journey and we try as much as we can within whatever possible way we can to put our clients back in the position they were, but for the accident, which is a principle of personal injury, i.e. it's about the journey to getting to the end, to that award of compensation, and it's trying to get somebody back on track, to get their life back on track through good rehabilitation, through early access to the best possible treatments. And it is about making that difference. And that's what drives me and makes a difference to me going into work. That's why I love what I do, because it's about that making the difference. And as perhaps corny as it may sound, that's why I do the job of serious injury law. I think it's helping people, really, because nobody wants to instruct a personal injury lawyer. It's what we call a distress purchase. Nobody gets up in the morning and thinks they want to instruct us, but they have to. and we're acutely aware of that. But as I say, that's our driver, really, trying to get people's lives back on track as much as we can.
Thanks, Richard. Yeah, we had a lot of good answers there, and wide-ranging answers from that perspective. Right, the next question is quite specific. I don't know if we have anyone that's practiced in London. The question is the workload in these practice areas as steady regionally as it is in London? I don't know if anybody's got any comments on this at all.
I mean, I've never practiced in London, but from what I see and when I speak to opponents, if you are against London Council, I think for PI, the Northern Circuit, the North is busy. I think Manchester and Liverpool, both of the county courts in those cities, do a lot of personal injury work and have dedicated personal injury judges, particularly that deal with serious matters. So I think there are big firms here, plenty of specialist PI counsel up here, and I think that you can have a busy practice. So I can't compare it to London personally, but having spoken to people in London and from my experience of working here, I think, yes, there is steady work and good quality work as well.
Yeah, I would agree with you on that. It's very, very busy in the Northwest, particularly in and around Liverpool. And of course, Birkenhead County Court as well gets very busy with these particular types of cases.
Well, I think the Court of Appeal recently recognised Birkenhead as being the stage 3 disposal LVI and low value capital. I think the Court of Appeal actually referenced that in one of the recent cases that went to the Court of Appeal on one of the RTA protocols. So yeah, I think that's absolutely right.
Certainly. Right. Okay. I hope that's dealt with that appropriately. The next question we have: can you give examples of common cases that arise in your practice area? So we'll start with Niamh. From a paralegal's point of view, what sorts of cases do you deal with?
Well, the team that I work under specialises in catastrophic injury. So it's anything from traumatic brain injuries to spinal injuries to amputations. Obviously, they're quite high value cases, and you might not, other firms may deal with lower cases. But generally, the work that we find ourselves dealing with is people that have had injuries that have ultimately turned their lives upside down. And it's your role as a member of their instructing solicitors, a member of their team, to guide them through the process and to make it as easy, as possible in those circumstances, to get through the litigation process.
Thanks, Niamh. And Andrew, as a pupil, what sort of cases are you dealing with?
So I have a PI, but also housing, say, practice as well, but so a bit of housing on the side. But from the PI perspective, it's usually, in my experience, and what I've found is there's causation arguments, LVI arguments. So I'm finding quite a lot of breach of duty has been admitted, but they're raising these other matters. Very few cases I've dealt with have actually been on liability. I think I've done 2 on liability and the rest have been causation, LVI. So that seems to be pretty much where I am at the minute. And drafting infant advices, I've been fortunate to be able to do quite a bit of that, and also pre-trial conferences, whether you take a case on under a CFA basis.
When you say drafting infant advices, would you like to just explain what the purpose of that is, Andrew?
Yep. So where a child, so somebody under the age of 18 has been injured in an accident, then in order for the damages to be approved, it has to go one before the court, and a judge will require, and the civil procedure rules require, that you have a court advice on quantum. So barrister or solicitor will draft an advice and say, I believe, or in my opinion, a reasonable award will be between X and Y. There are some rules, but if it's £100,000, whether you need one, but that will be what that is. So I'll be reading medical reports that will say, for example, a 3-month neck injury, and I'll be saying a reasonable award will be between X and Y. And you know that that's going to go before a judge as well. So you have to make sure that it's, dot the I's and cross the T's.
Thank you. From a slightly more senior perspective, Jamie, what sort of cases would you be dealing with on a regular basis?
across the board in terms of personal injury, so it can be from a road traffic accident, it can be an accident at work or on premises, or the full range really in terms of public liability, sometimes products that have injured people. But most of my work is probably RTA, so when there's been road traffic collision. I do plenty of fast track trial work, but there's also some multi-track work, CCMCs, getting quite a lot of those at the moment because of course they can be heard by telephone quite easily, so there are things that seem to be going in the list. So effectively setting a timetable for how a case is going to be dealt with from the outset. So what expert evidence do we need? What reports from various experts are going to be prepared? How's the trial going to progress in terms of disclosure? What do each parties have to do? How many witnesses? Are we going to have limits on and the pages of witness statements, or the typeface even is sometimes specified, or the size of the font? So it can be quite minutiae in terms of the detail that go into those hearings, and of course budgetings and what costs will be spent as well. So in terms of common cases, yes, there's plenty of the whiplash work, but I do a wide variety of PI work.
Thanks, Jamie. The next question we'll jump on to is what is the most difficult case you've worked on, and what skills were required for it? Do we have anybody that would like to offer an answer on this one?
I have a case to mind that I can talk about, actually. It's now concluded. It concluded a couple of years ago. I think it's a good illustration of the type of work we do, because just going back to the last question, we take whatever work comes through the door really on what we're instructed. So it can be absolutely anything. It can be road traffic accidents, it can be accidents at work, accidents in a public premises, so anywhere. But I was instructed some years ago by a client who was driving home one night. He'd been working abroad, he'd flown back into Manchester Airport, driving home to Anglesey where he lived. He was driving a camper van. He pulled into a lay-by on the A55, which is the road that runs through North Wales that people will be familiar with, because he was quite tired. It was early hours of the morning. He parked in this lay-by, got into the back of his camper van to make himself a coffee to wake up and then continue his journey. About 20 minutes later, he fell asleep. He was so tired. And shortly after that, there was a car coming down the A55 full of guys that had been celebrating St. Patrick's Day. It was March. They were drunk. They weren't really paying much attention to the road. They mistook the lay-by my client was sat in his camper van for a slip road, so they drove straight into the lay-by. My client didn't have his lights on because he was just sat in the back for a coffee and then fallen asleep. They struck his camper van at such force, they spun the camper van round. The doors flew open, throwing my client onto the highway, onto the A55. Where, I mean, you couldn't make it up, but where a minibus rather, of people coming back from Liverpool on a stag do, were driving down. The minibus then ran over him, unbeknownst to the minibus driver. And we were instructed to unpick all of that. So it's the skills you need. Obviously, it's almost detective work. Who's at fault? Is there any contributory negligence? My client was sat in the back of his van with no lights on. The driver of the car which struck him had fled, so he couldn't be traced. The car didn't have any insurance, so it was uninsured. So who do you pursue? Is a minibus driver at fault because he didn't see my client lying on the road, but should he have expected somebody on the road? So huge amounts of detective work. So that's the first port of call to reconstruct what happened, and we do that with experts that we can use, and we speak to lots of witnesses and the police, and then we start to build up the evidence as to what injuries did my client suffer, and what injuries did he suffer in each collision, and who was at fault for each collision. And eventually we settled it. It took about 5 years. Really interesting case, and he's doing really well, my client now. But that's the type of work, really. So I suppose expect the unexpected.
It's good to hear that he's doing well now. But it's almost like the stuff of law essays, isn't it? That exact problem you've described there.
It was like an exam question.
Exactly.
Even the QC on the case felt it like an exam question. Yeah.
Well, that's really interesting. Do we have anyone else with any suggestions of particularly difficult cases?
Yeah, John, I can help.
Yep, thanks, Mark.
I should perhaps mention, if it wasn't already obvious, that I do defendant work. So my view is that Richard's client was entirely to blame for his own injury and got all he deserved and should have got zip. Now, I had an interesting case a few years ago where a lady was working in a protected sort of cage in a baggage handling area in Heathrow. And you get these little electric powered tugs with a little chain of trailers behind them, and they're carrying your luggage on or off your aircraft. And one of these became slightly detached and was empty, just gently ran into her. She had stepped out of the protected area and was run into by this very lightweight, very slow moving little truck. Thereafter, she was mortally wounded. She couldn't get out of bed. She couldn't stand up. She couldn't move around in daylight. She was in terrible condition. And we had video, of course, because we're in the airport, of the level of impact, and the level of impact compared to the injury she was reporting was just wholly inconsistent. And in the end, it was agreed that she should go to a pain management clinic for a residential trial. And the problem was that she was adjudged by the experts to be too unwell to attend a residential session in the pain management clinic. So how did you deal with this? We couldn't get her on the pain management treatment because she couldn't go to the clinic. What do we do? And at that stage, I was self-employed, and the guy who's now my boss came to me and said, what do we do? We can't get her to the clinic to have her assessed. We can't get her treated. What do we do? And my advice was throw money at her. Give her £500,000 and walk away. And there was no justification for this. It was a question of simply buying off the risk. They didn't accept my advice, and we fast forward 5 years of litigation. Richard, having built up his costs outrageously during that 5 years, if he'd been acting, thus running up insurers' losses even worse. And we went to a mediation. We instructed Marc Willems from Cobden House in Manchester. And Marc negotiated a settlement with the claimant solicitors far below their 2.5 million claimed. And Marc was doing a really good job. And I said to him, when he got down to about 583,000, you must not negotiate it ever any lower, because I wish to retain the ability to say at 500,000, I told you so to insurers and my boss for the rest of my days. And sure enough, the case settled for 583,000. But there are cases sometimes where you just cannot get the claimant assessed or treated, and you have to take a pot and just pay the money and get them to go away.
Another interesting case there, Mark. And I think sometimes, quite often, from a defence point of view, I guess it is a case of cut your losses and run, so to speak.
What I didn't say, John, was that we had surveillance on her. We'd got private eyes looking at her. We got the whole stuff. And nothing was turning up the goods. She was being filmed 24/7. And sure enough, she was in the sitting room on the sofa watching TV in the dark, doing nothing. And we paid the money. Hey ho.
There we go. Right. Does anyone else have any examples of difficult cases? Or shall I move on to the next question? Yeah. Okay. We'll move on to the next one. What style of advocacy is most important, or which advocacy quality is most important for PI practitioners? Have any suggestions on this?
Well, I mean, I can only speak from the limited experience that I've had so far, but I don't think there's one style that will fit you. You have to adapt it depending on the situation. So if you have a conference with a client, for example, you may take a fairly pleasant approach at the start. But if you've got somebody who you think is trying to lead you up the garden path and you're trying to pick out inconsistencies and they're basically lying to you, you need to take a slightly harsher tone with them. So you can't really have one style. For me, I always start off, depending on the client, a bit gentle, and then you work your way into it. But again, it's on a case-by-case basis. You obviously just need to be meticulous and you need to be detailed, and you need to just be able to stand your ground and basically not take any rubbish, really, especially if you know it's rubbish, and be able to justify what you're saying.
Yeah, good advice there. And I think one thing to always bear in mind is that with personal injury in particular, whenever you're in court, you're always going to be in front of a professional tribunal. So you will always have a judge who is qualified by comparison to crime, for example, whereby you might be in front of a bench of magistrates or you might be presenting to a jury. So the big difference that you have there is that you're always going to be in front of a professional tribunal and therefore tailor your advocacy accordingly. And the other big thing in PI, and correct me if I'm wrong, is that you don't ask questions fully in evidence in chief. Effectively, the witness statement goes in evidence in chief. I'm right in thinking that, aren't I?
Yeah, that's right. Nearly all the times the claimant, well, all the witnesses, claimant and defendant witnesses, will give their evidence in chief by way of a witness statement. So that just confirm that it's right, and then it's straight over to the other side for the cross-examination. And I think just picking up on that point in terms of styles of advocacy, I've come to realise that it's important to have a good narrative style of advocacy. So particularly when you're at bar school, you want to do the cross-examination and the aggressive stuff and, you know, expose all these terrible liars, so on and so forth. But I think actually what's really important is having a good narrative style where you can explain things, particularly to a judge, as you say, a professional tribunal. So you need to explain it in a way that is professional, but makes sense and that they can follow as well, because there'll be a professional lawyer, but it won't necessarily be a personal injury practitioner. So just setting out, well, is this something that's medically complicated? Can I explain all of these medical terms and what are cases in a really simple way so the judge can follow? Because you are talking to one judge, and if you lose the judge, then they're not going to be with you. So just make it really straightforward for them. So I think just being able to explain things in a simple way is something I've come to realise is probably one of the most important things.
I think that's absolutely key. Simplicity is the way forward, and the easier it is for your tribunal to understand the point, and the more likely you are to be successful.
John, I think one of the things that Jamie said there was very helpful, and that is that you have to engage the judge. And I dabbled a tiny little bit in magistrates' criminal stuff and realised that my style was wholly inappropriate for magistrates and crime, because where I can, I like to introduce a little bit of humour in the thing, and the bench and the judge in a criminal matter do not think that that's funny. This is a serious matter, and if you're joking, you're not serious. Whereas in the civil arena, I find the occasional throwaway line and a bit of a joke just lightens it for everybody. And so what you have to do is balance your approach so that you can keep it a bit light, a bit amusing if you can. But then when you start asking the killer questions and you start explaining to a judge why this person is lying, then you turn on the very serious face. And so actually it's the ability to be a bit of a chameleon. And sometimes you're light and nice and jolly, and other times you are very serious and you treat this absolutely as a life and death situation. I remember one case I had with District Judge Khan in Manchester years ago, where I had an Asian witness who was clearly lying through his teeth. And I asked him a question. He said his brother was a semi-professional cricketer, and his brother was the victim in an RTA. And we were alleging fraud of some sort, I forget what. And I asked him a question, well, how much did your brother earn? And he said, well, I'm not answering that question. And I just looked up at Khan, and I looked up in a dead straight serious manner and said, please instruct the witness to answer the question. It wasn't a jokey moment, it's a very serious moment, and it just killed their claim because Khan just said, answer the question. So you flex between the two, the variants of approaches, but not in crime.
Well, you say that. I have seen humour used occasionally. I saw it not so long ago, actually, in Liverpool magistrates. And there was a particular advocate in court presenting a plea in mitigation. And on this particular day, there was a district judge rather than a bench. And he's presenting this plea in mitigation. And I think it was a possession of a bladed article. I can't remember, but I think that was the offence. And he turns around and he says, well, my client on this particular day, he knows he did wrong. He was knocking about with a bit of a wrong un. And the judge actually said it when delivering sentence, he said, well, in fairness, he was with a bit of a wrong un, and everyone in court just broke into laughter. So it can come in occasionally, but you've got to know specifically when to use it appropriately.
I got one in on it was in a magistrate's court. It was in Wrexham Magistrates Court. And the allegation was that my client had disturbed newts. And the prosecutor was a very young little girl. We were in a preliminary hearing. She was terrified. And I said to her, would you like me to explain the law to the district judge? And she said, oh, yeah, please. Oh, very frightened. So I set out the case. And our case was basically, there weren't any bloody newts in the pond when we drained it. So at the end of my submissions, the district judge on the bench looked down to me and said, Mr. Asquith, so in your case, no newts is good news. Later, at the end of the hearing, when we'd set it down for a preliminary hearing, I said to the judge, sir, can I just clarify, is this secondary hearing that's just a preliminary hearing, will that be a newt-on hearing? Mr. Asquith, in this court, I make the jokes.
There we go. We can be humorous from time to time. Right. On that note, I think we'll move on to the next question. This is for our more junior panelists, both of whom have secured pupillage. What particular traits would you say the chambers are looking for in applicants? Or what qualities would you think are important?
I mean, if I can come in, I've obviously just been through the pupillage process quite recently. And I had a few interviews, some for personal injury, some for criminal. And what I thought the key qualities that I felt they were looking for me, and going off the feedback that I got, was being a confident speaker and being able to speak articulately about your own experience. I think a lot of the times, a lot of pupillage applicants put pressure on themselves to fit into the mold of what a chambers expects. And actually what I found as I went through the process is the more that I spoke about my own story, as it were, and my own experience and the things that I had learned and the different things that I'd gone through during my career so far, the more that I spoke openly and honestly about those, my interviews seemed to go a lot better, and I became more confident as they went on. So I think my one advice in terms of being confident is take a look at your application and take a look at, the experience that you have, and look at what transferable skills do you have that you can bring to a career at the bar. So when I left university, I did a sociology degree and I had to go and do a graduate diploma in law. So I always felt that I was on a bit of a back foot and I was scrambling to get, law experience. But when I was doing my pupillage interviews, I actually realised that you can draw on non-law experience just as much as you can draw on your legal experience. In my successful pupillage interview, I ended up talking, about the fact that I worked at McDonald's as a shift manager throughout sixth form in university, because that taught me how to be a confident speaker and it gave me all these skills, and I was able to talk, really confidently about that. So yeah, I think that's my advice really, just draw on what you know as opposed to trying to fit the mould of what you think the chambers are looking for.
That's great practical advice there. Andrew, any suggestions on this one?
Yeah, I absolutely agree with what Niamh just said, because when I went for my interview, you go there with the expectation that everyone else will have the grades and the experience. So it's what is going to set you out from them. Now, for me, I went in, the first few interviews I ever had a few years ago, you go in and you go, okay, this is what I think a barrister should sound like, this is what I think a barrister should look like, and these are the answers I think will look good. And when I realised that actually that wasn't working, and just basically went in there and I was me and expressed myself so the panel could see, well, at the end of the day, yes, we've got 3 people, let's say, who've all got the experience, who've all got the grades. Who could we actually see fitting in here? Who is going to want to stay here? Certainly on the Northern Circuit, if Chambers going to invest time and money in you, they want you typically to stay as opposed to moving on, let's say, elsewhere in the country. And you know, if you look at your personality, come and get on with this person. Are they going to fit in? So for me, which is amazing news for me, apparently it's my personality. It's the first time I knew I had a personality, but apparently it was that which they looked at and said, yeah, actually we think this is somebody who would fit in quite well with Chambers. So be you, because if you're not, you will be quickly found out. And it's 12 months. It's a hard 12 months. And the last thing you want to do is to sit there and think, oh God, why did I, let's say, come across that way in a certain interview? And the last thing you want them to do is to think, oh God, why have we taken this person on? So be you. And if Chambers like you for you, you'll be fine. And if they don't, they're not the right Chambers for you. Don't change who you are for anyone.
Good advice there, Andrew. Right, we'll ask 1 or 2 more questions from the pre-prepared questions. If anyone can think of any questions that they've got on the night that they would like the panel to answer, feel free to pop them in the chat and we'll move on to those shortly. The next question that we have is it imperative to have a medical background for going into this area of law? Does anyone want to answer that one?
No.
Yeah, no.
I figured it was going to be a short answer.
I can expand on that. That's right. Going back to the previous question, I can also answer that from an employer's point of view, because I sit on the assessment panel, so I'm one of the assessors for our training contracts at Irwin Mitchell, and every year we have an intake of people that apply for training contracts, and we have a full day's assessment, and I can tell you what we're looking for, and it goes on to whether you need a knowledge of medicine to do clinical negligence. Well, the answer is what we're looking for is when we interview candidates, we're not really looking for the knowledge of the law or knowledge of medicine if they want to do clin neg, or knowledge of PI to do serious injury, because you can teach all of that and you can learn all of that. What we're looking for is other skills, personal skills, life skills, particularly whether they've worked in McDonald's or whether they've been out and whether they've travelled. I think that's just as important as work experience in a law firm, to be honest. In fact, more important. It's about the right fit and the right personality. It's about being yourself. I think when you go to the interviews, as we've already heard. So longer answer to the just no, you don't need a medical background, but no, I mean it's other skills are far more important. So work on your CV when you're making applications, but work on your CV to describe yourself and your skills and how you'll fit in, and for serious injury, for your empathy, and for clinical negligence, your attention to detail, and all of these other softer skills that you need to do the job. I don't think knowledge of the law and/or medicine is important, because they can be taught.
Good answer there, very comprehensive. And I think tagging on from that, another question that we've had is what sort of work experience is important for somebody to have on their CV if they want to go on and become a solicitor or barrister in personal injury?
Just on that, and I suppose that the earlier question as well about whether you need experience of medicine, it's definitely no. I agree entirely with that, because what one needs to remember is that, of course, in personal injury or clinical negligence cases, it's not for the barrister to decide medically what's right or wrong. You're relying upon expert witnesses. So really, it's not about medical knowledge. You defer to the experts on that. It's about judgment and analysis. Is what this expert's saying right? Will a judge buy what they're saying? Does it make logical sense? Can I present this in a persuadable way? Or actually, are they clutching at straws here? So I think it's more about judgment and analysis in terms of what work will assist. If you have got some medical experience, that won't harm, because it'll be up to speed with reading medical notes and all the acronyms that are used and things of that kind. So I worked for an HS 111 beforehand, so I saw medical notes, etc. So it will be of benefit to do that, but actively it's not essential. You'll quickly pick it up. And I agree that really what you're looking for is personal skills. So any job that you can do, if you can make it relevant, I suppose really that comes back to the skill of being able to, find evidence to support your proposition from your life experience. So, whatever it is you want to say, just find something to help support it. So be it working in a call center, or in A&E, it doesn't really matter. It's how you can use that to say, I'll be able to be good at this job because I have this experience.
John, I should comment.
Yes, please do.
I have one pal who is a defendant lawyer working within a primary care trust. And he is both qualified as a junior doctor and a solicitor. Doctor first, solicitor second. And I don't think there's anything wrong with having a medical qualification. It means he is able to very easily demand, he moves around a little bit and gets jobs easily if he needs them, and is very popular with his people because he is able to speak the language. I don't think it's necessary, but depending on where the questioner is coming from, if you happen to have the medical background, it can be advantageous. In my aviation work, I frequently defend claims against skydiving instructors. And for many years, we instructed a particular barrister who was a specialist in skydiving. He was an active skydiving instructor. And one day he got carried away, and the judge said to him, are you the advocate or the expert? So if you have expertise in an area, you have to be very careful not to slip from being the advocate to the expert.
Very true. Yes. Okay. So I think we have quite a comprehensive answer there. In short, no. But in long form, if you've got the experience, it's always helpful. I think what we'll do now is we will turn to the questions that have come through. So if you think of any more questions, please keep popping them into the chat. Right, the first question that we have, how realistic is it to aspire to combine clinical negligence or practice in clinical negligence with other related fields of practice in professional negligence or healthcare, or even areas of public law, such as community care? So can anyone answer whether you can combine clin neg with other related fields such as prof neg or healthcare? I don't know if anyone knows.
At Irwin Mitchell, we specialise and we're in very specific departments. So I only deal with serious injury law. We have a clinical negligence team that just deal with that, and we have a public law team that just deal with that. So we have niche teams that specialise in those areas, and we don't branch out. That's not the case in smaller firms, and I've worked in much smaller practices in my career, and you tend to be more of a jack of all trades. So it depends on the size of the company I think you work for. That the larger the company tends to mean that you specialise more. But if you work for a high street firm, you may do a bit more of everything.
Yeah, I would agree.
I suppose that's a very general answer, but yeah.
Yeah, I worked for a very large PI practice many years ago, and the focus was PI, but then they branched into professional negligence, and you tend to find that people were shoehorned into one or the other. You wouldn't flitter between the two. They were completely separate departments. But as you say, with smaller firms, you might be able to dip your hand into different practice areas. I don't know whether any of the barristers know if it's possible to have a mixed practice like that at the bar, or know of anybody that does.
I would think it, particularly as a junior barrister, that's perfectly plausible to have a mixed practice like that. Yeah, I mean, there are people in chambers who do across two different practice areas, so it's certainly possible. I think there comes a time where there's pressure from your solicitors. They want a specialist who knows about this one thing. That's what it feels like sometimes. But I think as a junior barrister, you could well have a practice, and ultimately you're self-employed. Chambers will want to do a certain thing with you, depending where the need is for them and the work they've got to service. But ultimately, you're self-employed. So if you want to do something and it's a key interest of yours, then you just make time for that in your diary and you do that kind of work. So yeah, I think that is certainly possible as a junior barrister.
Thank you. Good advice there. The next question we have, what aspects of your work do you find most challenging and how do you manage these? So does anyone want to comment on a particularly difficult or challenging part of the job?
I wouldn't say it's necessarily difficult and challenging, but it's one thing you'll learn is that you could get given a case at the last minute and it could be hundreds of pages long, hundreds of pages of medical records, and you need to go through and you need to read each and every one of those, and you need to be able to set the time aside to do that, and you need to give it your full attention. So, you know, you could be sat there 10, 11, 12 o'clock, 1 o'clock in the morning and you're going through it, and you might think it's difficult, it's challenging, especially when you see all these papers in front of you, but you need to just develop a system of being able to deal with it, because you have a duty to do the best for your client, and your client isn't going to have that if you go in half prepared. So that can be a difficult aspect, trying to juggle the amount of work that you get and making sure you do it properly, but it's one you have to get right, and you have to learn very quickly how to get right.
First one thing about if I were to comment on anything would be occasionally you have litigants in person, not often, but I had it on a few occasions, and I found that speaking to a litigant in person before a hearing that you're against can be quite challenging at times, particularly if they don't understand the process. So that was something that I found particularly difficult when I was doing PI. I think somebody else was about to jump in then.
Yeah, I was going to pick up something more parochial than that. I mean, I think Andrew was entirely correct, but he didn't quite say it right. And I'm now putting my barrister hat on and saying that when you're self-employed, particularly very poor solicitors who think they can just dump their entire file of papers on you in pretty random order late in the day, and you will then wade through these papers trying to work out what the case is about. They've not prepared a proper brief. They've not ordered the papers properly. They've just simply shoved a random file through a photocopier. And it was with complete terror that I used to read these papers late at night, thinking, in here is something I need to find. And there's a blooming trap for me that I won't find it. I'll fail on the case and then be accused of negligence, because solicitors will say, well, I sent you the piece of paper. Yes, but it was hidden within 500 pages, you rat. And you didn't tell me it was there. I had to find it. And so I found that particularly stressful a lot of the time, that people would just dump their entire file on you. In my more solicitory role, one of the challenging things I just hate with a passion is time recording. At least as a self-employed barrister, you take as long as it takes and you send them a bill. And you don't have to tell them how long you did or none of that. You just send them a bill. But I find myself struggling day in, day out to get down the 1 unit of time I spent looking at this case, the 2 units of time I spent thinking about it while I was on the loo, etc., etc. And time recording as a solicitor just drives me nuts. I hate it with a passion.
And that's a common theme. I think that's probably what you would hear a lot throughout the solicitor profession, really. Time recording is a bane of our lives. So each unit that Marc mentions, each unit is 6 minutes, so 10 units per hour. We record 70 units per day generally, so everything is time recorded. So every piece of work you do, you then log against the file. So it's quite laborious, and you have to meet your targets because that's how we're measured. So So that is a frustration for us all. The other thing I would add about what's perhaps the most challenging aspect of the job is when we act for clients, we're faced with a client who we meet at quite an early stage, usually following an accident, a very serious accident. They've had a life-changing injury. The family's at a very low ebb, and we have to meet them in very difficult circumstances. And we then follow them through the journey for many years, and the cases typically can last 3 years or 4, 5, 6 years. They're very long time. You get to know a client very well, and you get to know the family very well. You genuinely have a connection with them, but it's a very fine line between the empathy that you need to be able to do the very best you can, but understanding the difficulties they're facing without having any personal connection to become involved, to say, I feel so sorry for them and I feel upset that they're in this situation, because you can't do your job properly if you do that. And I'm sure, as with any doctor would say, you know, you have to have that professionalism at all times. It's a very fine line between the empathy and then perhaps the personal, the sympathy as well. So it's maintaining just that right side all the time.
Yeah, I think that's absolutely important, having that empathy, particularly if you're delivering bad news to a client. I remember sometimes, you know, we would take cases on which sound great at the outset. You'll do the investigation, send all your papers across to the defence, and it turns out they might have a legitimate defence in law, and you can't actually take the case all the way through to court or through to trial, and you have to break that news to your client that you can't really proceed any further. So to give examples of that, it could be, you know, a trip in the street. Common case would be, you know, a paving flag comes up, somebody trips, has an injury, and you'll sue the local council, and the council will say, but we inspected it within, I think it's a 12-month period. They have to inspect section 58. And quite often they'll say, yeah, we did the relevance inspection, and you've got no case there. And you have to tell your client that, unfortunately, even though they've been injured, there's a legitimate defence in law and you can't continue any further. And it can be quite difficult for clients to understand that. So you've got to be able to put that across to them in an empathetic way. So I think you're absolutely right there with the communication skills with clients.
I think just building on that as well, sorry, in terms of when there is a successful case or a case that you can take on and it does last a number of years, as Richard said, I think a difficult aspect of the job is managing your client's expectations. Often the litigation process is completely alien to the client, and this is the first, you know, experience they have of the process, and managing their expectations that, you know, this case is quite a protracted process, and it might be 3 or 4 years down the line where we do reach settlement or even reach a trial or even reach the first court hearing. Often that's, you know, really alien for a client to hear, and it's kind of like, oh no, I've put in my claim and I expect the compensation. It's explaining to them the process of getting the medical evidence and getting the witness statements and so on. And I think that's a really difficult part of it, to explain that effectively. Yeah.
And the other one, when you actually do settle a claim and you'll say to your client, right, the check's on its way and they've spent it before the check comes through. big one around Christmas time.
It's one of the defendant tactics, is to start teaching the claimant's lawyer to manage their client's expectations. We will make a low Part 36, for instance, a low offer to settle, not because we think it's going to be accepted, but because that will bring the claimant down from thinking he's going to get 3 million quid to thinking he might get 3 quid. And so a lot of this is tactical and frequently is not a lot about law. It's about strategy, and it's worth learning a little bit of game theory. And since I'm talking, I just want to mention the irony of listening to John's accent talking about slip and trip accidents in Liverpool.
Yeah. Well, to be honest, Liverpool City Council are quite good on them now. I think they got hammered in the 90s, so you'll never win a slipper and tripper in Liverpool now.
They did. They took the view that they were going to pay all slipper and trippers because it was cheaper than paying the lawyers. Yeah. And suddenly everybody was throwing themselves on the floor in Liverpool.
There we go. Right, okay. Next question. Do the cases you work on ever take a toll on you emotionally due to the upsetting nature or the injuries? So is anyone ever upset by their work?
Yeah, I don't think we'd be human if we weren't. So yes, it's going back to the earlier answer. It's very difficult to maintain that fine line. I act for seriously injured children, which I find difficult having children of my own. I do quite a few fatal cases, so where I'm having to speak to a bereaved family. And it's very difficult to keep a lid on it sometimes because you really feel for these people, but you have to. You have to hide that emotion and perhaps let it out in another way. But yeah, it can be very difficult.
Thanks, Richard.
It takes a certain character to do this job, I think.
Yeah, absolutely.
He's a big softie. His
Empathy,
clients always exaggerating their injuries, and I very rapidly run out of patience for them. So no, they don't affect me at all. I mean, I defend insurers on fatal accidents. I did one a few years ago where a chap deployed his parachute. He was out skydiving, deployed his parachute, and it went wrong, and he was receiving radio instruction and being told that he should deploy his reserve, which means releasing your main canopy and then going into free fall again briefly. And when it got too low for him to do it, they stopped saying deploy your reserve, at which point he decided he was going to do it, and he hit the ground before the reserve deployed and died. And frankly, I have little or no sympathy. I understand the pain and anguish for his family, etc., but he did it to himself. So I mostly am pretty harsh. Even the genuine claimants invariably exaggerate to a certain extent. So those of us who are defense lawyers are pretty hard-hearted, and I'm not affected one jot.
Wouldn't be good at your job if you were.
I'm slightly different. Oh, sorry.
No, I was just going to say I've got one case at the moment on one of the big American carriers where a lady had a pot of coffee spilt on her lap, and she has particular gruesome injuries to a particular part of her body that I don't wish to refer to, and we're still defending it to the hilt. Not our fault. Sorry, love. Go, Andrew.
I was going to say, I'm slightly different. So I've got Asperger's, so I've very little empathy, and I don't understand personally why people would get upset or something by these matters, because I just look and think, well, it's not happened to me. I don't understand it. So mine's slightly different from a slightly different perspective. But yeah, I've seen people who can be quite upset by it. But some people just say, well, it's part and parcel of the job. I'm just that's slightly different for those slightly different reasons.
Yeah, I think it allows you to be objective, really, doesn't it, Andrew? So you can be impartial with the cases and simply look at it from a legal point of view. Yeah,
but when people start crying in front of you just sit there and I'm thinking, oh God, just stop this. I'm like that with family as well. I'm terrible at funerals, but it is slightly different. I just look and think, right, this is where it is. Let's get on with it.
Yeah, definitely. So there we go. Mixed bag of responses in relation to that one. We've got a question specifically for Richard now. What are you looking for when you look to instruct a barrister?
Empathy.
Sorry, Mark, you're not getting the brief.
No, I'm joking. I suppose there's a whole host of things, but it's somebody with great attention to detail, somebody that will fight tooth and nail for my clients, somebody that certainly won't roll over in court, somebody who's always well prepared. Yeah, I think somebody who does have a strong PI background as well. And we talked about whether you should specialise in more than one thing. So I suppose a whole host of reasons. We often instruct barristers that we've used previously or that we've been recommended. That's often the way we find our counsel. I suppose all of those things really is somebody that will do their very best for us, which I'm sure everybody on the panel would.
I think one thing I would say on this, from my time when I paralegaled in personal injury, the thing that was always important to us was quick turnaround of papers. So quite often we would send papers to counsel for either advice or drafting a particulars of claim or whatever it might be. If we were going to be sending instructions to a barrister and 2 months later we're still chasing it, they weren't getting a brief again. Quite often, if barristers can have a turnaround in less than a week, they were always going to get the instructions continued. So quick turnaround of papers in, depending on the area of law, but if it's your general slippers and trippers, RTA, whatever it might be. I think quick turnaround of papers was always a key factor for us. And of course, it's got to be quality work as well.
If I can try to rescue my reputation with Richard, one of the things that my clerks used to say to me when I was self-employed was that solicitors liked me because I was a fighter. It is imperative that you don't give up, that you keep going, that you fight every inch of the way for your client. And if you've got a judge who is against you, don't roll over and die. Get up and fight again. I remember one judge saying to an opponent of mine, who wouldn't bloody shut up with his submissions, he said, "Mr. So-and-so, I'm giving judgment, not inviting further submissions." But the point was that this guy fought every inch of the way and never died. And that is the important bit, is you do have to be a fighter. And if you just give up at the first stage, you wasted your life.
Words to live by right there.
Yeah.
Right. The next question is for our claimant lawyers on the panel. Did any of you have, or do any of you have, any defence experience? And if so, do you think it helps you with your claimant practice?
From my perspective, yes, I've done some defendant work as well, and it always helps if you approach it. You've got to approach it very, very analytically and look at it and go, okay, I know what we're saying, but we're presenting this to a completely independent party in the judge. How are we going to have this come across in the best possible way? Okay, what are the other side going to be saying? What are we going to be arguing against? You need to look at it from both angles, and if you don't, you can't prepare properly. I don't think anyway, because if somebody says something which you should have thought of or could have thought of but haven't, then you might be floundering a little bit. So you need to look at it and go, okay, can we present it in the best possible way to get our case across in the best possible way to this independent party?
Good advice there. I think that's applicable across the board. If you've got experience of one side or the other, you can certainly use that to allow you to think and effectively play devil's advocate. Right, okay. I think we've got through most of the questions there that were in the chat. I'll just give anyone a chance to pop the hand up if they think of any other questions. No, can't see of any. Can't see any hands going up. So I think we'll take this opportunity to move on to the final segment of the evening. So what we're going to do is, one by one, I will ask our panelists to leave us with a final piece of advice, just some parting words or some words of wisdom to leave our students with tonight. So I'm going to work my way around the screen, and I'll start with Niamh. Any final words for us?
Yeah, if I could just focus specifically on those looking for pupillage, because I think that's where my most recent expertise comes from. The main piece of advice I could give, and it might sound cliche and you might hear it all the time, but is literally just to be yourself and use your own narrative to explain why those reasons and why that would make you a successful barrister. It's the only thing that's going to work, because it's the only thing that you're going to be able to speak passionately and enthusiastically about. And then just the second point that I would make is that you might be tempted to send out as many pupillage applications as you can and just, type them out, get them done. That's not the right approach either, I would say, because I think it's important to be selective and it's important to research that chambers. And what I found is you'd be surprised at how many, especially junior barristers or even pupil barristers are willing to just have a chat with you, find them on LinkedIn, or, if you've got contacts another way, and just have a chat with people and get their experience and why did they enter the law. And it will just give you a more well-rounded approach to the application process.
Thank you. Jamie, any final words for us?
Probably just one point really, which is for people who want to go to the self-employed bar, which is self-discipline, because you are your own boss, and I think chambers want to see that you are able to discipline yourself and get on with your work. You don't need to be told you won't take advantage of the fact that there's no one looking over you all the time, particularly at the moment. Pupils are working from home, etc., etc. No one's checking up on you really. You want to make sure that that you're just getting on with the work and you can do it and motivate yourself. So I would say, from my view, is when you're applying to chambers, just demonstrate, if you can, that you do have that self-discipline to get on and you can work independently on your own. So that's probably the only point that I would raise.
Thank you, Jamie. Marc, any words of wisdom for us?
Tempted to say no, but I've not looked at the application for pupillage recently, so I may be slightly out of date. But one of the things that people need to be aware of is if you're applying for pupillage, the numbers of applications that are piling into chambers are huge. And so you're simply going to be selected on a yes, no, on a first sift. So it is well worth making sure that you highlight that you have at least a 2-1, that you have at least the equivalent of what used to be a very competent. And so they can go, yes, he's in. He's a 2-2 or a not very competent, as I like to call it. No. And they can sift you very quickly. To give you a flavour of it, when I was our pupillage selection person at Young Street, we got 187 applications for one pupillage. And it was a stack of CVs, that thick. And it's just a question of doing that stuff. So that's the first thing. If you don't get pupillage, you need to strengthen, or a training contract for that matter, if you want to be an advocate, you need to strengthen your CV. And I would always recommend joining one of the in-house advocacy teams within the firms of solicitors. I know DWF have a very big one now that I founded years ago and only had 3 or 4 people when I was doing it, but is now up to 30 advocates. And you can join as a paralegal and get really good basic advocacy experience so that in a year or so you can renew your application to pupillage and go forwards. And if you want to look around the Manchester bar, I would suggest there's Kevin Latham, Jamie Marriott, Jonathan Robinshaw, and a few others who went through the process with me and then got pupillage. So that is a strong recommendation. And it is possible to enter the profession without pupillage. And I would encourage people to explore both the way to get into the solicitor profession and the bar without getting pupillage. I have never done a training contract. I have never done pupillage, and yet I am both qualified as a solicitor advocate, a solicitor, and a barrister. It is possible. You just have to be a bit like the Borg and the Terminator. You will be assimilated. Resistance is futile.
There we go. Inspirational words there. Richard, any final advice for us?
At Irwin Mitchell have today actually just launched our social media channels. So on LinkedIn, Twitter, and on our website as well, the procedure for application for a training contract. And it's a virtual booklet which contains quite a lot of advice, and it talks about the process that we adopt and what we're looking for and how to apply. But that's for training contracts in 2023. The process opens on Sunday, so you can see how far in advance we recruit. So I think the piece of advice I'd offer is it's never too early to start looking. Start preparing now. If you want a training contract, wherever that might be, start preparing and even applying now, even if it's a couple of years in advance. The mistake I made when I applied for a training contract was I waited until I graduated, then started looking, and it was way too late. Needs to be done very early on in your law degree. And bear in mind what we said earlier about the skills, and as Niamh said, that being yourself and the skills that you have that might not be necessarily in law but elsewhere will build up those skills. Do something different. Do something that stands out on a CV, because we also get hundreds and hundreds of CVs for any particular position. It's so competitive, more competitive than it ever was. and it becomes ever more competitive each year. So do something a bit different. Do something to make yourself stand out in an application, and make sure you flag it up on your application. And then the final piece of advice I would say is just be aware of where you're applying to. Don't send a bespoke, don't send a generic letter to a company. I want to apply here. Do your research, find out why you want to work there, find out what the firm's about and what the ethos is, and then tailor your approach, because that's what we're looking for as well. Somebody who wants to work for us and has demonstrated why they want to work for us.
Thank you. Great advice, Richard. And lastly, Andrew.
See, one of the great advantages of going last is that pretty much everything you were going to say has already been said. So I can only really echo what has already been said. Be yourself. I try to always make my extracurricular things stand out. So, for example, I'm a martial arts instructor, done cage fighting, played rugby. So all those different things which give you something different to talk about in an interview. Be yourself, be meticulous, be tenacious, don't give in. If you want it, keep going. And yeah, just if you need to, go out there, you go and get the experience and go back and take the time to really focus on each and every application rather than just being generic.
Thank you.
Yeah, just echo what everyone else has said.
Yeah. Great advice again. So that brings us to the end of the evening then. I would like to say thank you to all of our panelists tonight. Thank you for the students for turning up and asking some very good questions as well. This is the end of our second series of Q&A sessions, and I have to say I've thoroughly enjoyed every single one. I hope that you've all found these to be very valuable. I thought with this particular session and this series, we would focus on a different area of law each time. So hopefully you've picked up some good tips and good advice into the various areas. I'm hoping to run some more Q&A sessions and YouTube sessions next year, so keep an eye out for those. If you did miss out on the opportunity to enter our upcoming speed mooting competition, we will be launching another advocacy competition in the new year. I'm hoping to have sign up launched in the next week, if not the week after. So keep an eye on that. If you want to join our mailing list, go on to speedmooting.com/contact, and you can sign up for the mailing list and be notified as soon as sign up is launched. So that brings us to the end. Thank you to everyone that's attended. Tonight's session has been kindly sponsored by publicspeakingintuition.com. And on that note, I would wish everyone a good night and take care. Bye now.